the task force interested parties meeting. This is our outpatient surgery setting task force, and we have some changes, so that's why we've invited everybody here today. We want to hear from you. Your input is really invaluable to us, so we just are very excited that you came, and again, thank you for coming out and attending. I do have to tell you, you'll have to be patient with us today. This is the first time we've done a video conferencing meeting of this type. We usually do staff meetings and things like that, so we've tried to branch out. So we'll have to be patient with those of you at the other end as we move forward. Before we get started, I just wanted to give you a little bit of background on this task force. As most of you know, SB 100 went into effect, and when that did, there were a lot of things that the board had to implement based upon that legislation. In addition, there were a lot of high-profile media articles that were presented regarding outpatient surgery settings, and the board wanted to ensure that the laws and regulations were up to date and that consumers were being protected in the outpatient surgery setting. So they established a task force. Our task force is made up of 2 members, Dr. Ganadev, who's here with us in Sacramento, and David Serrano-Sewell, who you'll see down in the bottom there in San Jose. So those are the 2 members on the committee. We've met a couple times. We've gone over the laws and regulations. We've really met to review information requested from the accreditation agencies. We asked for information. We went through all of the information that we received to see kind of so we can get a starting point as to what's going on in the approval of these outpatient surgery settings, the accreditation. We also met to see where board staff was. The task force wanted updates on where we were on the database and putting in the information that was requested from SB 100. And then the last thing, we really met to look at and make improvements to our website. And for those of you who are here when you go back tomorrow, we're hoping that today we'll update our website for outpatient surgery settings. We've done actually almost a complete rewrite of the pages that we have. And again, input, we always value input, so if you have something out there where you think isn't clear, please send us an email through our webmaster account, and we can go ahead and look at the page and see what's wrong. But we really have improved it and made it more user-friendly for both consumers and for individuals looking to find information on outpatient surgery settings and the accreditation agencies. So that should go live either later today or tomorrow. And then lastly, the task force really wanted to meet to review the laws and regulations pertaining to outpatient surgery settings. One thing that really came up in our discussions was that through SB 100, the medical board, we believe, should have been receiving adverse event reports rather than the California Department of Public Health. So most of you know that that went forward in SB 304 last year, and so as of January 1st, we're receiving those adverse event reports, and those are actually, the report form is on our website. So we hope everybody knows where it is and is using that form. The second thing that we really wanted to look at was after Capon versus Shulry, there was information that was gathered by the California Department of Public Health regarding outpatient surgery settings and ambulatory surgery centers. We use those synonymously, those 2 terms. That wasn't being received right now, and so we actually have a proposal that's been approved by our board that we're finding an author to carry that piece of legislation. So those are the things that we currently have going on. And then of course the last item that the task force really did was they went through every law and regulation, and what you have before you is the outcome of their review of the laws and regs that they think need updated. And so what we asked everybody to do today is, as we go through them, we want to hear from everybody on how these changes, if they were passed either via legislation or regulations, kind of from you guys, how that would impact your businesses, how it would impact everyone, and how you feel about those changes that were going to be made. So with that, I'm going to kick it off to Dr. Ganadev if he has any opening remarks, and possibly David, and then we'll be moving on.
Thanks, Kim. As Ms. Kashmoyer mentioned, that the task force went through quite thoroughly what the regs were, what the law was. I met with all the accrediting agencies. They came and made the presentations at the board meeting. So after that, we basically took 2 things into consideration to coming up with the changes in the regulations. Number 1. It's always number 1 for medical board is consumer protection. Number 2 is access to care. Make sure that there is an access, adequate access to the surgery centers for everybody. So these are the 2 things we Three, which is along with the protections comes quality of care, which was very important for us, how you monitor the quality of care. So we took all that into consideration, and that's where we are. And I do want to thank my associate task force members. That was Dr. Salmonson and David Serrano.
So Mr. Serrano, do you have anything to add down there?
Hello, can you hear me?
We can.
Yes, we can.
Can? Okay, I'll get used to this very shortly. But I wanted to amplify the doctor's comments, and the chief purpose of this task force is to enhance public safety and public patient protection. And so this task force went through a very deliberative process with staff. I also want to thank Kimberly and your staff for this mess. And there'll be some great suggestions and dialogue today, and looking forward to today's hearing.
Thank you. So as I said, it is a video conference, so what we're going to do is we're going to be going through each suggested edit to the laws or deletions to the law, and then at the end we'll offer public comment here in Sacramento, and then we're just going to go in alphabetical order. So Cerritos would be next, and then San Diego, and then San Jose. And if you guys would just take turns going around and making comments on the item that is before us at that time. Please don't repeat comments that someone else has said. If you want to state that you agreed with the individual who spoke previously, please do that just in order for us to get through all of the items. And then at the end, we will open it up to items that haven't been outlined by the task force, to anything else that anybody wants to bring forward, any changes that other recommendations that individuals have. So with that, I'm just going to start with the first one, and hopefully everybody has a copy of the packet that was in each of the offices as a handout. Okay, so the first change that the task force recommended is to Health and Safety Code section 1248.15, and it would actually eliminate basically 2C3. And the reason that that was recommended was due to the pathway that was there in 3, the task force did not feel provided adequate consumer protection. So with that, I'd like to offer anybody that wants to make comments on that section to come forward. Vaughn doesn't want to be first. And if you can come to the microphone there. It's up to you. Don't want to turn your back.
Turn my back's on everybody over there.
Okay.
Good afternoon. I'm Yvonne Chung with the California Medical Association. I'd like to thank the board for this opportunity to comment on these proposed changes. We agree with the board's position that there could be changes to statute to better enhance patient protection and access to care. However, we do have concerns about several of these provisions. On this particular provision, our main concern is that by removing this language here, the surgery centers are essentially, their ability to operate is essentially tied to approval from the area hospital, and many times there can be competition issues there. It's potentially anti-competitive if a hospital can essentially prevent an outpatient surgery center from operating by virtue of withholding privileges. I think sometimes the way that what's required for medical staff membership varies quite a bit across the state as well. And I think some possible unintended consequences which would limit the ability of outpatient surgery centers to open include, for example, some medical staffs require board certification as a condition for privileging. And as you know, medical licensure does not require board certification, so it's entirely possible that a physician could be prevented from obtaining privileges at the local hospital because he or she is not board certified. And so that's potentially a barrier. Another barrier is some physicians are actually prevented from being on staff at a hospital if they previously had an exclusive contract with the hospital, and as a condition of contract termination, the physician is prevented from practicing at that hospital for economic reasons. Again, not related to quality of care, but is another barrier that prevents a physician from obtaining privileges at that hospital. So I think that because of the way that medical staff membership and privileging occurs and the wide spectrum of what is required can differ so widely, I think that the board really needs to think hard about what the implications of removing this language are. If you want to put in something else there, I understand what the issue is here, but I think that removing this entire section probably is not the way to do it. So we recommend further consideration. And I think there are others who can speak to some of the details of this more. Thank you.
Hello, I'm Jack Bruner. I'm a physician, plastic reconstructive surgeon here in Sacramento, California. Have practiced for 42 years and just retired last year. What the lady was referring to is economic credentialing, where it's possible that, and it did in fact happen to me, I was involved in putting together a very large surgery center in the early 70s because no one else seemed to be interested. We were in a plastic surgery group. We were licensed briefly, and that was eventually removed just for that's the way the laws went. But we were eventually accredited, and by quadruple ASF, and we kept that accreditation for quite a long time. And as things progressed and evolved throughout the Sacramento community, I did most of my surgery at my surgery center, and doing less and less reconstructive surgery at the hospital. And eventually, I lost my admitting privileges and my hospital privileges because of that. Now, I relied on paragraph 3 that there's been a recommendation to exclude this or delete it, and to continue doing my plastic surgery business. And thank goodness it was there. And AB 395 years ago, authored by the illustrious and very nice lady, Senator Spear at that time, perhaps she was in Senator, but she authored that, and this is one of the reasons this was included in that, because we knew that without that conduit, there will be a number of plastic surgeons and other specialties who are slowly but surely losing their hospital privileges. That's the way medicine was evolving. We would no longer be able to practice in an outpatient setting. So it is, in fact, what the lady was mentioning in the CNA, it is a very real entity. It does happen. It happened to me. And I would recommend that we not exclude this. Thank you.
Hello, Tim Madden, representing the California Society of Plastic Surgeons, and we concur with the comments made by the California Medical Association and Dr. Bruner, and I'll just give you a couple quick examples that we've been hearing from our members as it relates to economic credentialing and the importance of retaining the third option there in this area of law. And it seems to be happening particularly in Southern California, where a number of our physicians are not being extended privileges or being granted transfer agreements unless they do a certain number of procedures at that facility. So it's an unfortunate trend that we've been seeing over the last 2 to 3 years that has a real impact on their ability to practice. And a lot of it just comes down to straight competition, and the hospitals are in a position to do this and try and squeeze these folks out of the market. So just wanted to add on to the importance of retaining this option for surgery centers. Thank you.
I don't see anybody else. Oh.
Good afternoon, Victoria Santerre with the Institute of Medical Quality. We are one of the accrediting agencies accepted by the Medical Board in California. I agree with everything everybody has said. I commend you for revising the laws, the rules. I would address 2 points. First, also, they've all talked about the privileging point, but the other important part of this particular area is the transfer agreement. And we have found many of our facilities have informed us that they have asked for transfer agreements at the hospitals nearby, and they have been denied transfer agreements because, and here's the reason that the hospitals are given. Given EMTALA, the national law that requires that any patient that arrives at a hospital cannot be turned back, there's no reason for a transfer agreement. It costs a hospital, according to the hospitals that have discussed this with our accredited facilities, $1,000 a year just to maintain a transfer agreement. That's, in the paperwork and having somebody there to do it. And they see no reason to issue a transfer agreement when, by law, EMTALA, they have to receive the patient anyway. So, in closing, we would also agree that item C is very important for access as well as for fairness. Thank you very much. Do you want me to go to Serena?
Yeah, just to give you a comment, we'll look into all the comments made, but item C2 actually takes care of a lot of your concerns you expressed. That is that you don't have to have admitting privileges. You can have an agreement with a physician who can take care of your complication. So it's one of the two you need to meet, item 1 or item 2, not both of them. So that's why I think we thought that with the patient protection was so important. Item 3, among discussions among all the board members, we felt that you can drive a Mack truck through it. So that's why it was very concerning for us. But we'll consider if there is any other way we can assist you. But item 2 takes care of a lot of your issues.
And then moving to Cerritos, and we hear the comments there. And if you could maybe identify yourself there so we can hear as well. Does anyone have any public comment in Cerritos?
No.
Okay, thank you. San Diego. Do you have any comments?
Yes, this is Julie D'Angelo Felmuth from the Center for Public Interest Law. I actually support the elimination of is it 2? Or the 2 little i's?
3.
Sorry, 3. I am sympathetic to the concerns expressed by the physician associations and the accreditation agency, but I agree with Dr. Gunadev that 2 can take care of several of those comments. And I applaud the board's direction in proposing to eliminate this subsection. Only because I'm aware of a physician down here in San Diego who has lost his hospital privileges at every hospital he ever had them at. He has prior discipline. He has current pending disciplinary action. He has criminal convictions. He has malpractice judgments. And this is a person who should not, he is the sole owner of an outpatient surgical setting, and he should not be allowed to qualify. The only way he qualifies is under this provision that you propose to eliminate. And so we support the direction that the board is going in. Either eliminate it or substantially stiffen it, because as I agree with Dr. Gunadev, you could drive a Mack truck through that provision.
Thank you. Anything else from any of the offices? Mr. Sharnosul, do you have a comment?
Yeah, thank you for the comments from the public. And I don't find the anti-competitive argument to be persuasive when you're weighing the merits of both of the arguments. And so fully supportive of eliminating this subsection to language.
Okay. All right. If there's no further comments, then we'll move on to the next change. And actually, I'm hoping we don't have any comments on this, but the next change is actually just bringing that change into compliance, basically with it stricken, because an outpatient surgery must comply with the other subsections. So that's just kind of a clarifying edit, the next one. Any comments on that? That's also on page 2. If not, then we would move on to page 3. And the edit there, it's 2-3, the edit there is adding a 6I, and that would require basically all physicians who perform procedures in the outpatient setting are required to have peer review evaluations, including outpatient settings that only have one physician. The peer review shall be performed by California licensed physicians who are qualified by education and experience in performing the same types of procedures. And as you can read in the paragraph below there, the task force really just felt that in order to ensure consumer protection or to enhance consumer protection, that all physicians working in these settings should have some type of peer review, no matter whether they were a large facility or a small facility. And so with that, we would open it up to comments from individuals in the audience, first in California or in Sacramento.
Me again. I just wanted to let you know that I don't think there is any accrediting agency that does not have peer review standards in their standards. We do require that physicians, even if they practice in a single physician setting, have peer review. And we definitely look that the peer review is from someone who is a peer, i.e. has the privileges to do the same procedures and does the same procedures, so that the peer review is definitely from a peer. So again, we don't have an issue with that, but I just wanted to let you know that all the accrediting agencies already have standards for peer review. It needs to be done yearly at a minimum, and it needs to be used for recredentialing as well. So there are very strict standards for peer review. Go ahead. No, go ahead.
Yvonne Chen with the California Medical Association. We are supportive of any kind of ongoing professional practice review of physicians, either in a hospital or in an outpatient surgery setting. Our only issue with this language is that the board may want to clarify or specify what exactly would qualify as a peer review evaluation. It's been our experience that many facilities define peer review differently. If it's according to the standards of the accrediting agency, that should probably be specified. Is it just chart review? Does it require proctoring? So depending on what the board is envisioning, we'd just like to know more about what you see as appropriate peer review, and then we'll be able to comment further. Thank you.
Good afternoon. Tina Manassi, and I'm here on behalf of the Consumers Union Safe Patient Project, a nationwide campaign that's organizing patient safety advocates from across the state of California as the California Safe Patient Network. Consumers Union Safe Patient Project California Network is disappointed and concerned to see how few and fairly minor are the medical board's proposed changes regarding outpatient surgery centers. We are supportive of the proposed amendments in the document Medical Board of California Outpatient Surgery Center Interested Parties Meeting, January 22nd, 2014, with the exception of two proposed amendments, which the Consumers Union Safe Patient Project opposes, as Kim already mentioned on page 2-3, NBC's proposal. At the October 2013 NBC Quarterly Board meeting, it was asserted that this proposed peer review concept would make unnecessary a Consumers Union Safe Patient Project recommended requirement that physicians performing surgeries that require general anesthesia in an outpatient surgery centers be board certified and also have hospital privileges for the specialty procedures they're performing in outpatient centers. According to a side-by-side distributed at the Medical Board's July meeting, only one of the 4 accredited agencies requires board certification now. In early testimony before the board, that accreditor referred to this as non-negotiable item. Apparently, the other accreditors allow the physician owners to create their own rules regarding who can perform which surgeries. Consumers Union urges you to add these requirements of board certification and hospital privileges. In addition to our concern that this peer review amendment not replace a recommended amendment requiring board certification, we are concerned that the peer review amendment itself is weak. How would this proposed peer review happen? Who would pay the qualified California licensed physicians to do the review? Could the physicians be reviewed also be the payer? Could the physician reviewer be a partner in the practice? If the physician is performing a variety of surgical procedures, might several qualified California licensed physicians be required to do the review? What peer review rules would apply? With whom would the results of the peer review be shared? There is not even a minimum requirement for the OSS to disclose to the accreditor and the medical board how they are complying with this peer review mandate. Many outpatient surgery settings are small establishments, and conflicts of interest are likely as the amendment stands. Patients would find it very difficult to believe that an arm's length, unbiased peer review is likely without much more carefully drafted, detailed approach calling for a consistent and trustworthy process to protecting patient safety. Thank you.
Tim Madden, representing the California Society of Plastic Surgeons, and we just want to make a comment on the second sentence of the proposed language, which talks about the peer review shall be performed by physicians who are qualified by education and experience in performing the same types of procedures. And we're encouraged to see this language in this proposal. And I think what we have seen in the past is that you have certain specialties providing peer review on procedures of which they have no connection. For example, a radiologist performing peer review on plastic surgery procedures, which I think is very problematic and obviously raises some serious consumer protection questions. So we're encouraged by this. We would encourage the medical board to go further down this road and specify what exact the qualifications are when talking about education and experience. We just want to thank the board for opening up the conversation and going down this road.
So actually, I'm going to take just a moment as Dr. Brunner comes up. I wanted to ask Ms. Sampre if she could comment on whether the accreditation agencies, when the peer review, does it have to be in the same specialty or the same practice area? Just to clarify that for us all.
Let me clarify a couple of things. Peer review is a big issue, and we do have a number of standards that address peer review. It cannot be done. So basically, if you have 3 or more physicians who practice the same privileges, have the same procedures, they can do internal peer review. That is not unlike hospital peer review requirements. If there are less than 3, then they need to find an external peer reviewer. The peer reviewer must not be connected to the physician by blood, marriage, or economic binds. The peer review is not chart review. In peer review, you are looking at the adequacy of the physician as a physician. Is he treating the patient properly? Is everything that he's doing adequate? Is it what should have been done? Do you have any specific questions? I'm trying to think through my peer review standards.
I just wanted to say, so they do have to be, are they in that specific specialty? You're saying that they do. So in response to Mr. Madden's comments.
Yes and no. So let me explain. For example, you have a head and neck surgeon. A head and neck surgeon can do anything above the neck. He can do eye surgery. And you have a plastic surgeon who can do eye surgery. Can the head and neck surgeon peer review the plastic surgeon for his eye operations? Absolutely. They have the same education. They may not have the same title or specialty, but yes. And they're certainly doing the same procedure. Okay?
Thank you.
You're welcome.
Dr. Brunner again, plastic and reconstructive surgeon. Been a member of the California Society of Plastic Surgeons for many years and have also been an owner and helped govern a quadruple ASF office for likewise 4 decades. or actually 3 decades for them, because I've been in practice for longer. I'm very supportive of this paragraph. I think it's a good idea that we visit that. Through regulations, this language has been some of the most difficult to deal with. And I've had a long-term experience in helping write some of these regulations, especially in 651, et cetera. And it's a real, you can hit a lot of landmines along the way and restraint of trade issues and things like that. And I really commend the task force for putting this in and starting the process to strengthen the peer review process and also the language of who is a good peer reviewer. Obviously, it seems that common sense would dictate that someone who is a peer reviewer must be hopefully board certified in that particular issue that they're doing the peer review on. If they're not, they're less trained. And there's a couple of areas of language that I have found very helpful, using the terms core training, meaning training received at residency, or formal training outside of residency that is meaningful to that specialty. And I'm not at all referring to a weekend course by a non-specialist taking a specialty course in any kind of training. I think we can see the difference. And board certification, using the terms board certifications in the paragraphs like this strengthens it. For example, if I were to rewrite this paragraph and strengthen it at the part where it says California licensed physicians, I would say California ABMS board certified licensed physicians. And further on where it says about education, in the first paragraph it says review education including outpatient setting, I'm sorry, I was reading the second paragraph where it says by education and experience. Well, you can say core training education, and that strengthens that substantially. Education at this point in time can be anything and everything that a physician can expose himself to. That's online training, weekend courses. And again, I'm saying this in the spirit of protecting the public and to try to, maintain good, professional, safe, adequate medical care. Thank you.
Okay, any further comments here in Sacramento? Okay, moving to Cerritos. Any comments on this item? No? Okay. Oh, is there someone in Cerritos?
Yeah, no comments.
Okay. Then moving to San Diego. Any comments there?
Julie D'Angelo Falmouth from the Center for Public Interest Law. I have a question and a comment. My question is, the language says all physicians who perform procedures in the outpatient setting. Do you mean all physicians or physicians who perform procedures in the outpatient setting for which accreditation is required?
Answer is which accreditation is required.
Okay, so I think that should be clarified. My other comment is that I agree with Ms. Chung that either in the statute or through regulations, you should clarify standards for peer reviews, because not everybody has the same interpretation of that term. Who should do it? How should it be done? How often should it be done? If the AAs are already requiring peer review, then I don't think they should oppose including language like this in a statute. But I would appreciate a little bit more specificity as to how it should be done, by whom it should be done, etc.
All right. Anything from Mr. Strano-Sewell?
Yes, thank you. The central theme of this proposed language, in my view, is to, it provides clear policy, it's a clear policy statement from this task force, and hopefully the board, that we value peer review. Meaningful, comprehensive, uniform peer review. And it's been my experience, short tenure on the medical board, but it's been those instances where a physician is outside of the peer review arena, that issues arise. And that's not across the board, and I'm not making it, but that's been one of my takeaways. And so the impetus behind this is to not draft language that is so ambiguous that you can drive a Mack truck to it. Rather, to state a policy that we think peer review is important. Whether you're a solo physician operator at an outpatient surgery center or you have other colleagues there, we want peer review. To Tina's and Julie's point, though, I think there does need to be some specificity and further guidance from this task force staff and board around what we mean. Because we don't want every accrediting agency interpreting it their own way without any sort of consistency. We want to provide to patients, as Tina said, well, as I took her to say, provide to patients the clear, unambiguous assurance that this peer review standard means something. And I think it will. Clearly, there's some more work that needs to be done, and we should do that. But there's strongly that this peer review component will improve the quality of care and patient safety at these outpatient surgery centers.
Thank you all. Actually, unless you're a physician practicing, often you don't know what details of peer review are. CMS has strict guidelines what peer review are. So what we will do is we'll come up with the details, just like CMS does on peer review. And this is what quality of care is all about. And this was very important for us, along with the consumer protection, quality of care. You could be protected by marginal quality of care. It doesn't have to be high quality. So our goal is to provide all these service centers to provide high quality of care, peer reviewed by appropriate physicians who can do the same. So we'll come up with more details, but this was very important task for us to come up with, which was not in the regulations before, and it was only done by each agency by their own way.
All right, then we're going to move on to the next one. And this is actually a change to Health and Safety Code, section 1248.3. And it's dealing with basically how long the accreditation can last for. And so this, we changed it to initial certificates of accreditation shall be valid for not more than 2 years, and renewal then would be the 3 years that it currently is right now. And again, as you can look in the paragraph that follows, really this is again to enhance consumer protection by ensuring that those newly accredited outpatient surgery settings, they actually have their first inspection within the first 18 months to 2 years. So with that, I'm going to open it up for comments on this change, and here in Sacramento.
Victoria Sampere with IMQ. Initial certificate. I think we need to clarify, is this a facility that is up and running, seeing patients, doing procedures under local, and now wants to start doing procedures under conscious sedation and general anesthesia, and therefore you go in and you give them their first certificate? Or are we describing a facility who's going to totally new start seeing patients? The reason I ask is because when we do a survey of a totally new facility, we only issue a certificate for 6 months because they have not seen patients. We have not been able to review medical records, logs, surgery logs, medication logs, and so we're not going to give them even 1 year. We want to come back within 3 months to say, okay, you said your policies and procedures were all in order. Let's see that you're following them and you are seeing patients safely. So I think a clarification on whether that's a facility that's up and running and changing what they're doing, or if it's a brand new facility. Just a thought.
If any of the accrediting agencies have somewhat tighter guidelines when they will go back and see them within 6 months, I don't think we have an issue. We want to make sure that any facility, whether it was treating under local, but now took on another job, which is conscious sedation or moderate sedation and general anesthesia, in our minds, it is actually doing something new. So it has to be evaluated sooner than a fully accredited facility which is coming for a renewal.
And I would think even for the 6 month, whether it's the one that's brand new or the other, I don't think we want to make a distinction between the two, because if it's one that's been going for a long time, even once they change to do that anesthesia at that level, we want them to go back within 2 years. For the 6 month one, we'd also want you to go back within that 2 year limit. So I believe that our initial thought was it didn't matter which one of those. We wanted somebody back in there to make sure that there was a shorter time to look at what they were doing within that last time frame. So, and I believe
And
Mr.
if you want to
Shaughnessy-
go early, I don't think we have any issue. I think if agencies want to go within 6 months and make sure that they're okay, we're not going to prevent you from doing it. But we want to make sure that any newly accredited center, whether it is changing to the next level or brand new, all needs to be seen within about 18 months time period.
Dr. Jack Bruner, I'm a Quad A SF inspector. Have been for years and have quite familiar with what we're talking about here. And I, as an organization, the officers that I've spoken to do not object to this change. On the other hand, I just as a reminder that when you review the safety records of quadruple SF that I can speak about, is it's a very stellar safety record that shows this change in the law. It may not change the safety issues one iota in our state, because the safety records are so supremely good at this point in time. But it seems somewhat illogical that after someone is accredited, that this accrediting agency feels that perhaps it should be looked at sooner. 6 months might be a little too soon, but because of the good safety records for the last 15 years, it hasn't been broken, so we're not fixing anything, but we certainly don't adamantly oppose the change, but we just wanted to say that we will certainly agree to it because it seems like the right thing to do.
Anyone else here in Sacramento? Okay, then moving to Cerritos, any comments there? Okay, hearing none. San Diego?
Julie D'Angelo Feldman from the Center for Public Interest Law. I just want to say that we support this change.
Okay, all right, Mr. Serrano-Sewell, anything from San Jose?
Supportive and no further comments.
Okay, and Dr. Gardner. Okay. All right, then moving on. Okay, so this is actually a change to Health and Safety Code 1248.35, and it is B2, and basically what we are looking at here is changing the inspections to require that all inspections be unannounced after the initial inspection. And again, just as in everything, again, this is just really to improve consumer protection. So with that, we'd like to open it up to comments here in Sacramento.
Yvonne Chung with the California Medical Association. Our concern with this language is, well, there's a couple. First of all, I think without standard agreement as to what constitutes an appropriate inspection, this does raise some concerns, because if inspections are unannounced, you may not see everything that you are hoping to see during an inspection. For example, with a small surgery center, they may not have a procedure scheduled that day. If that's not if that's not important, that they actually view a procedure, then it's not an issue. But if you want to have the surveyors get the full experience of what's going on at that surgery center, this may require additional follow-up visits, which then incurs additional cost on the part of the surgery center. You know, each time they come out, it could be several $1,000s to get a survey team out there. And if you keep missing procedures, that's going to start to add up. So I think what's needed here is perhaps further clarification of what you intend to inspect while you're there. If it's sort of a set number of things that can be seen when an inspection is unannounced, then that may be fine. But if there are other things you want to see, you may want to think about reworking the language. Thank you.
Anything else here in Sacramento? Okay, any comments in Cerrito? Oh, I'm sorry, we did have one more here.
Dr. Brunner again speaking for Quadruple ASF. Here's the Bible that's used for Medicare Quadruple AFS approvals. There must be a couple of thousand items in there that we must go through to find a deficiency. And here's another one for the standard approval of Quadruple ASF. It's not Medicare approval. Probably 600 or 700 deficiencies. This is with a standard approach for Quadruple ASF. It's an announced, scheduled visit, and with the Medicare, it's an unannounced one. And when we take these organizations, and just as a point of information, I'm not speaking in support of an unannounced visit. It sounds like it's maybe a safer thing to do, but statistics and safety statistics don't really prove that that is a valid approach. Sounds like a good idea to anyone, of course, but in the practical matter is that when you review the safety issues, untoward events that take place in Medicare Quadruple ASF facilities as compared to non-Medicare announced visits, there's really no difference. And I can see that it's probably not a greater burden to the system, but it can be. And it's hard to say that it's really a good idea because of patient safety. It just seems like it is, but statistics don't support that. Thank you.
Dr. Brunner, I have a question for you. So if you go to a Medicare surgery center and they have no procedures on that day, does that hinder your inspection, or does it make it for you to go back and add additional cost?
Well, yeah, you must go back when they're operating. There is a way to find out if they're doing business that day without tipping your hand, so to speak. That's a good question, though. To show up and there's no one home is kind of embarrassing for everyone. So thank you for your question.
Thank you.
Okay, anything else here? All right. Moving to Cerritos. Any comments in Cerritos?
No, none.
Okay. San Diego?
Yes, Julie D'Angelo Felman from the Center for Public Interest Law. We support this proposed change as well. It's very consistent with Senate Bill 100, which actually deleted a requirement that the accreditation agency provide reasonable prior notice in advance of an inspection. So this is just clarifying that after the initial inspection, follow-up inspections shall be unannounced. And I think that it's very consistent with SB 100.
Okay, thank you. I hear other speaking. Is there any other comments anywhere? Okay. All right, moving on then.
Okay. Yeah, Dr. Brunner, thank you for your answer. I think what we are looking at is we rely on the judgment or the accrediting agencies to go unannounced, but make sure that something is going on rather than door is closed. So in the end, we want both. That is, something should be happening at the same time. Make sure that it's unannounced. It's easy to just get spiffed up on one day when you're going. And all the hospitals now, CDPH, CMS, everyone, Joint Commission, they all come unannounced. So the surgery center shouldn't be any different.
All right, then moving on to the last two, and I'm going to take these actually probably together because both of these changes actually are bringing our regulations into compliance with SB 100. So the first change is to the Title 16 of the California Code of Regulations, and it's section 1313.4A3, and it's just removal of that section because it's no longer applicable since statute pursuant to SB 100 now requires all locations to be inspected. That's the first one. The next one is elimination of section C of that same section. And again, it's no longer applicable because now the notifications are actually in statute that we need to receive. So both of those are just bringing us into compliance, our regulations into compliance with SB 100. So are there any comments on those two clarifying changes? Okay, seeing none here. Any in Cerritos or San Diego? Okay. Okay, then moving on, this is our last item, and so this is actually opened up to anybody who has any suggested edits or changes that are outside of the ones that the task force has actually presented and come to a decision on. So we'd open that up for anybody that wants to come forward.
I did have a comment on section 13,
Okay.
13.4. I'm here on behalf of Consumers Union Safe Patient Project. On page 2.8, the changes to section 13.4 subsection C should retain the first part of the subsection to ensure that the board knows when an OSS has received accreditation. If this language is completely removed, there's no requirement for the board to receive this information in a timely manner. Language such as the following should be included to assure timely reporting to the medical board. An accreditation agency shall, within 14 calendar days after issuance, provide to the board a copy of certificates of accreditation it issues.
Actually, the reporting requirements are now in statute, so they're actually more stringent than that.
Okay, great, thanks.
Hello, I'm Debbie Mack from the California Ambulatory Surgery Association, and I do want to thank the board for all your work and effort here. I think it's very commendable. We would like to request, this is outside of this document, is since we're required to report 805s, we'd like to go on record to also be able to access 805s. We used to be able to, as state licensed, when we were all state licensed. Unfortunately, since CAPEN, obviously, some of us still can do it, but there's many of our surgery centers that cannot access 805s. Any questions? Thanks.
Okay, any other comments here? Yes.
Tim Shannon, representing the California Orthopedic Association. There was earlier discussion about peer review and tightening up that language, and my last comment reminded me that Section 805 also defines what a peer review body is in a peer review process.
Hello. Susan Chinese. I'm here on behalf of Consumers Union Safe Patient Project, more specifically California Safe Patient Network. In addition to our comments on the medical board's proposed changes, we recommend the medical board make additional changes in the interest of protecting patient safety. Hundreds of thousands of surgeries are being performed in California at these accredited surgery centers that are the responsibility of the medical board. So we urge you to apply rigorous oversight, maximum transparency, and wise policy direction in the case of these surgery centers and their accrediting agencies in the areas of one, full disclosure of information to support informed patient decisions, and two, maximum protection through high and equal accreditation standards. Regarding the various agencies that accredit physician-owned outpatient surgery settings, we recommend the board require that any deaths occurring within 30 days of a surgical procedure performed in an accredited facility be reported to the accrediting agency and the medical board after the facility is notified or otherwise becomes aware of the death. The current law requires a report to the MDC only in cases where there is a determination that the death was caused by the procedure. We also recommend the board require surgery-centered patients that require to be transferred to a hospital or emergency center for medical treatment exceeding 24 hours be reported in a timely manner to the accrediting agency and the medical board. We recommend the board require any significant event, including adverse actions taken against an outpatient surgery center by other entities such as the CDPH, CMS, or any other state, federal, or private entities, be immediately reported to the accrediting agency and the medical board. We recommend the board also require the surgery centers that are seeking accreditation post a notice on the premises 6 months prior to finalizing the accreditation to inform employees, patients, and the public how to confidentially contact the accrediting agency about any concerns they may have regarding patient safety at the surgery center, and also require upon receipt of a complaint from the medical board that an outpatient setting poses an immediate risk to public safety, an accreditation agency inspect the facility within 24 hours. And if the accreditation agency is unable to perform this within 24 hours, the medical board itself performs the inspection within 24 hours. The current law requires such an inspection by an accreditation agency in the face of immediate risk to public safety, but that requirement allows 5 days to perform the inspection versus the 24 that we're asking for. Thank you.
Anything else here in Sacramento? Okay, moving on to Cerritos. Any comments from Cerritos on anything that hasn't been discussed today? Any other changes or recommendation, edits, deletions?
Yes, I have a comment. My name is Dawn Terashita. I'm a physician who's representing the California Association of Youth Controllers, as well as the California Conference of Local Health Officers. We applaud all your efforts for patient safety and all your suggested improvements. We have developed a set of recommendations that I believe were distributed to you. They have a detailed document which includes different infection control measures we think should be put in regulation for ambulatory care settings, both including ambulatory surgery centers, but other outpatient settings as well. I just wanted to highlight some of the bigger changes we recommended. We suggest creating a level system or a tier system of outpatient settings, and we would like to define level 1 and level 2. Level 1 settings are outpatient settings that perform procedures that include surgical or invasive procedures requiring minimal sedation, invasive pain management, infusions, therapy, transfusions, autologous blood injections, and injections other than into tissue and muscle. We believe all these types of facilities should have require accreditation by a CMS-approved accrediting organization. And we further defined a level 2 facility as a facility that performs procedures that include surgical or invasive procedures requiring moderate sedation, deep sedation, or general anesthesia. These level 2 facilities, we ask that they be now require licensure by California Department of Public Health licensing and certification. We also have detailed recommendations about training, quality assessment, including infection control standards, reporting, and inspection that we would like to see to enhance patient safety and reduce healthcare-associated infections and outbreaks. So what we propose is that we work together, the California Medical Board and our organizations, to develop further requirements and regulations.
Okay, thank you. Your document, is there any way you can email that to us or get it to us? If you give it to the office staff there, we can get that?
Of course. And in fact, I think we have a representative in the room, Pat,
Oh, okay.
who can do that.
Okay.
We also have proposed legislative changes for places in the code we think needs to be changed.
Okay.
I'm sorry, I missed. Who do you represent?
Well, I'm representing two organizations, the California Association of Communicable Disease Controllers, as well as the California Conference of Local Health Officers, CCLHO.
Okay, thanks.
Okay, any other comments there in Cerritos? San Diego?
Yes, Julie D'Angelo Thelma. I have a couple of comments. I went onto your website today, as I do often, to check up on how well you're doing, or not. You've actually made great strides. However, I looked up a bunch of OSSs, and for a number of them, I looked for about a dozen. And for about half of that dozen, there were documents that were supposed to be attached, like the report of the accreditation agency, the corrective action plan, and the outcome report. And there's this little PDF thing that you're supposed to be able to click on and read the report, but it's not there. Is that what you were referring to, Ms. Kirkmeyer, as you're undergoing an overhaul of the site?
No, we're actually making changes to the language on the site. So
Oh, okay.
those should be there though, the forms.
I could not open any of them on any of the sites that I searched.
Okay, the ones that we have received, they're all posted on the database. So,
There may be an issue with the PDFs.
we're,
She's saying she went in and clicked on
I got
them,
that
but nothing
404
comes up.
error notice. It's
Oh,
not here,
okay,
it's been
no,
temporarily
no.
removed or whatever.
that's news to us. So thank you for bringing that to our attention. We'll go back because you should be able to click on those. If it shows the little icon, you should be able to click and they pop up. So no, there's a problem then with our system.
Okay, good. The other issue that I just wanted to put before you is something that I touched on at an earlier meeting. These statutes and regulations have primarily to do with the requirements of the accreditation agencies and the outpatient surgical settings. But there's nothing in these, or nothing that I know of anywhere, that discusses how you as medical board staff and members are going to track the activities of the accreditation agencies to make sure that they're not falling down on the job. You referred earlier, Ms. Kirkmeyer, to a number of high-profile news articles and cases. I'm aware of the 1-800-GET-THIN debacle in Los Angeles, where a number of people have died at clinics connected with 1-800-GET-THIN. And, you know, those clinics have been inspected and accredited by one or more of these accreditation agencies. So I'm interested in learning more about how the medical board plans to track the accreditation agencies to make sure that they have not fallen down on the job and that they are allowing, unsafe outpatient surgical settings to continue operating.
Well, Julie, may I speak to that point?
Sure.
Thank you. And for everyone else. You know, I have that same concern. And it's always, the regulatory, statutory context right now is what it is, right? I mean, the medical board does not have direct authority over the surgery centers, except in some instances. The regulatory relationship right now is between the medical board and the accrediting agency. I asked staff, and I think you were at that meeting, you know, how can we assert, if we wanted to, and the circumstances arose, how can we assert that authority? We have that relationship, medical board, accrediting agency. How do we go about enforcing and, you know, I guess it sort of is what it is, and we do need to have this conversation because, as I understood it, could, on our own volition, institute some sort of order and revocation of the permit, suspension of the permit. You need certain findings for that under the statute. Or we could, that every 3 years when the accrediting, or so, I think it's 3 years, when the accrediting agencies have to re-up, we could deny their application. I mean, it's a permit, right? It's revocable at will. That's my understanding of a permit, although there's some standards. So it's always been a little, you know, and I know the disconnect, I feel there's a bit of a disconnect. I think the public does too. I think what you're speaking to is, you know, and I for one am open to suggestions, because I do think there ought to be more flexibility and discretion, quite frankly, by the medical board, because if we do have the belief that an accredited agency is not doing their job, you know, it's, you know, we have to afford some due process, I suppose, but it becomes quite cumbersome. And if an accredited agency is not doing their JOB, we ought to be able to do, you know, interim suspension, something that really demonstrates to the accredited agencies that if they fail, this board means business and we will suspend their authority to accredit surgery centers. Because that will get their attention, in my mind. So I just wanted to comment on that because it's always been a bit of a challenge for me anyways to understand it all, piece it all together. It's quite indirect, the authority.
It is, and prior to SB 100 in 2011, I think your comment about the relationship is accurate. The relationship prior to SB 100 was between the Med Board and the accrediting agencies, and then the accrediting agencies had the relationship with the settings. But SB 100 actually gives this board much more direct authority over the actual outpatient surgical settings. You can now, the medical board can now inspect the surgical settings. You can go to a DA or bring an action to enjoin a violation of these laws, and you can bring an action to shut down an outpatient surgical setting. So there's a little bit more room for the board to wiggle in there, but you know, we've had this discussion at prior board meetings. This relationship, this whole regulatory scheme has been in place for almost 20 years now. But this is the first time the Med Board has actually taken any initiative to examine it and try to strengthen it. And I applaud that, but I want to see you go farther in terms of putting some detection mechanisms in place that might alert your staff and thus you as a board to accreditation agencies that aren't doing the job.
Such as, what would be some, this is a hearing, let's drill down on this just for a second, if that's okay, Kimberly and Deb. You know, what could be some of those, you know, working with another governmental agency such as the local district attorney's office, that poses its own set of bureaucracy issues. You know, without passing judgment, I think everyone could recognize that. Shouldn't stop us, but it is what it is. What would be some trigger mechanisms that the board could consider directing staff to that could help? I'm serious. I mean,
I would have to think about this. Repeat offenders should trigger some heightened scrutiny. Repeat complaints. I don't know. I'd have to think about it more. I want there to be detection mechanisms in place at the board so that what happened at those clinics connected to 1-800-GET-THIN does not happen again. And I continue to believe that you need to institute some sort of signage at these clinics that indicates who the AA is, and that may already be in place, I'm not sure.
It's already in
But
place.
okay, thank you. And that the AAs are approved by the medical board, and that the medical board can also receive complaints about the facility or the people who are working at the facility. Because otherwise, many people have no idea who regulates these clinics. And they not only have no idea who to file a complaint with, but they have no idea how to find out more information. They don't know to come to your website.
Thank you, Julia, and thanks, David. Actually, we do have a lot of authority, and we just need to implement it, number one. Number two is that CDPH was receiving all the adverse events till recently. The law now makes it that medical board gets it. So we weren't even aware of what, because the law transferred the regulatory authority to the medical board, but never transferred the adverse event reporting from CDPH to the MBC. So that was a huge issue which was corrected this year, last year when the law was passed. So we will be getting those adverse events, and we'll be sharing with the accrediting agencies, and if they don't perform, there are disciplinary guidelines we already have. I think what it is we need to be a little more transparent for people to really send it to us, and there is a requirement that they have to post that they will be there under the Medical Board of California, and this is the accrediting agency. Anyway, any consumer can call the medical board, and they can send the complaints to us. So some of the weakness in the previous law was already corrected. I think there are places where we do need to improve. But our goal is, as we said, the primary issue is patient protection, so we'll do what it takes.
My understanding is, Kim, that the board, haven't brought a lot of actions against surgery centers.
No, we haven't brought any against a surgery setting, but again, we haven't received a complaint. And I'm going to look to our complaint manager in the back here. The last time I checked, we had 6 complaints. I think that may have gone up to 10 complaints, but every one of those complaints at the time that we had received them were for an unlicensed facility. They weren't for the care that was being provided there, the treatment that was being provided there. There was no crash cart, for example. They weren't those types of complaints. So from the complaints that we've received, we don't see that there's an issue. Again, there are issues with physicians in those settings, and that's where we get the complaints, and that's where we go after the physician performing the surgery. But as far as complaints against outpatient surgery settings themselves, we're not seeing those complaints coming in. But I do go to what Ms. Felmuth said, they may not know where to complain, and so that's part of the whole revision of our webpage and letting people know where they can complain and that they can complain. And then as soon as that website is up and running, one of our, I think the task force had discussed this earlier, was that part of our goal here is also to provide outreach. So getting outreach out to consumers groups that they can make complaints to the medical board about the outpatient setting, as well as to the accreditation agency, which has the notice posted in the setting. So that was kind of where we're coming from at this point.
Well, thank you. I mean, it sounds like we have some tools here, and we can exercise them and use them. We just need a more cohesive theme, perhaps. And some, as we're gaining an understanding about how we can go about implementing these tools, we need more of a cohesive theme. I think to the public outreach, crucial, but also, and it's probably already happening, Jim, but our communications to the accrediting agencies beyond, giving them the permit, but because they're one of the main contacts as well for the center. They've got to communicate on our behalf, or communicate to them that the board takes this stuff very seriously, and there's going to be enforcement of what you may not expect. So, do your job. They can communicate that on our behalf, since they're dealing with them a lot more frequently as we are.
Okay, and I think we have one more comment here.
In San Diego?
In Sacramento. Is there?
Oh, okay, I thought we were in San Diego.
Hi, Julie.
Making a comment.
Oh, sorry.
Hi, Tina.
San Diego, you have one more comment as well. We'll get to you in just 1 second. Sorry.
Okay, no
I'm
problem,
sorry.
thanks.
I actually have the same exact concerns that Julie and Mr. Serrano have. As a matter of fact, I brought this up to Consumers Union yesterday. By the way, my name is Tina Manassi, I'm a patient safety advocate for California. I'm a survivor and a victim of a doctor who operated on me in an outpatient surgery center. I still live with all the pain and suffering from that surgery till this day. I still have spitting sutures coming out of me 12 years later, and I suffer from excruciating back pain. Now let me tell you something. If you're charged by the legislator to protect patients, why would you leave it up to the AA to monitor and regulate doctors who own OSSs? It's your responsibility to regulate doctors, not the AA. Here's the problem that I have. You're relying on the AA to provide you with information, accurate information. How do you know it's accurate? And I'm going to tell you about a case that's closed. Okay, this is a real good case for you. Dr. Efren Gonzalez, license was revoked in 2006 in Puerto Rico. You gave him a license here. AA accredited him. But prior to him getting accreditation, he was already operating on people in his own surgical center. His own surgical center in Rockland. So he was accredited with a revocation license in Puerto Rico, and he got a license from the Medical Board of California. How did that happen? 15 people were injured by this one doctor. Some of you have seen the news stories on CBS 13 News called Curtis. I don't understand this. In the state of California, you don't require a doctor to have a specialty license in doing certain surgery. All you need is an MD license to do surgery. In the territory of Puerto Rico, they require a specialty license for plastic surgery. Dr. Efren Gonzalez was a gynecologist performing plastic surgery in Puerto Rico. His license was revoked. And then he comes to the state of California, and we just hand him a license and say, congratulations. And then AA gives him an accreditation, and he's already operating in his own operating surgery center. He was operating in his own surgery center without even being accredited. They should have caught that, and you should have caught that. So my question is, why is it possible that a doctor in California can operate in his own surgery center and not be trained, board certified in the specialty? A foot doctor can perform brain surgery, a pediatrician can do a heart transplant, and a gynecologist can perform tummy tucks and breast augmentation. How is that possible? The consumers of California are just fed up. This is not right. I'm one of those victims of a doctor who had many adverse issues with patients, but I wasn't his only victim. I was one of many hundreds of people that were operated on by the same doctor. Yes, he's lost his license, but I still live with the lingering effects of what he did to me. And many people are gone. They're dead. They're not here with us today. So I urge the committee to really take a look at this. How do you know what these AA people are really about? When I looked at all their website, guess what? 99% of them are doctors. Isn't that interesting? So it's the fox guarding the hen house. Thank you.
Ms. Manassi and I, we're sorry for what happened to you. Our goal is consumer protection, period. That's what we're doing. By these regulations, a podiatrist or a foot doctor cannot do brain surgery. By these regulations, a gynecologist cannot do extensive plastic surgery. We got all these things here. We respect your opinions. We are doing what what's right for the consumers. And we are sorry for what happened to you.
Okay, San Diego, I think you had one more comment. I'm sorry to cut you off down there.
Yes, my name is Carol Moss, and I'm here on behalf of Consumers Union Safe Patient Project. As you know, our nationwide campaign is organized on behalf of patients and the consumers of California and throughout the nation. With the passage of SB 304, effective January 1, the medical board began receiving adverse events reports pertaining to accredited outpatient surgery settings. The medical board staff has indicated to us that the board plans to disclose on its website fines against physicians who fail to report adverse events timely. We urge the medical board to also post on its website adverse events reports it receives from outpatient surgery settings. For your information, CDPH will post facility adverse events online in 2015. Also, the law says consumer groups and journalists who request the information from CDPH may have it. Consumers Union and other media outlets have regularly requested and received this information, and we recommend that the medical board do the same regarding accredited outpatient surgery settings. We also urge the board to post online the full history of accreditation, including any disciplinary actions taken by accreditation agencies or the medical board. We notice that some pre-SB 100 information is now available for some centers, but not consistently. On a recent productive call we had with the Medical Board of California, Acting Executive Director Kimberly Kirchmeier and the Medical Board Public Information Officer Cassandra Hawkinson, we were told that when accrediting agencies make historical information available to the medical board, the board posts that information. We were also informed that the medical board does not have all historical information regarding these accredited surgery centers. However, Health and Safety Code requires that accreditation agencies conduct reasonable investigation, which means querying the Medical Board of California to ascertain if the outpatient setting has been subject to an adverse accreditation decision. How can the medical board possibly fulfill this requirement if it does not have historical information? We urge the medical board to remedy this situation and gather and provide on its website all historical information regarding California outpatient surgery settings, including disciplinary actions. Consumers should have the access to the information to support them in making well-informed and safe choices. The California Health and Safety Code currently requires accreditation agencies to conduct an investigation that includes investigation of prior history of all licensed physicians and surgeons who have ownership and interest therein, to determine whether there has been any adverse accreditation decisions rendered against them. The medical board should seek a change in law to require that accreditors not only determine whether there have been adverse accreditation decisions, but also to determine a physician's own status and history with the medical board, including whether the physician's license is in good standing and whether there is a history of reprimands, probation, suspensions, etc. The medical board should also assure that accreditors are required that outpatient surgical settings are following prevention standards as established by national experts like the CDC. The law should require all outpatient surgical settings to report on healthcare acquired infections that occur in its patients. This could require a 30 to 90-day follow-up with patients. Several states, Colorado, Missouri, New Hampshire, New Jersey, Oregon, and Texas, already have laws requiring outpatient surgery settings to report their infections. Regarding data collection, this summer, the California Healthcare Foundation released a report entitled The Ambulatory Surgical Centers, Big Business, Little Data. Among other things, the report found that little is known about freestanding ambulatory surgery centers operating in California. The state medical board, which oversees physicians' owned facilities, does not mandate public reporting. The report explains that when outpatient surgery centers were brought under the purview of this board due to a 2007 court decision, Campen versus Shuri, all requirements for these surgery centers to report data to the Office of Statewide Health Planning and Development, OSHPD, were removed. As the board attempts to improve its oversight of these surgery centers, it needs basic data such as which surgeries are being performed, patients' diagnoses, the volume of surgeries being done, and other information that was historically required to be reported to OSHPD. We understand that the medical board plans to propose legislation to require outpatient surgery settings to routinely report OSHPD information about the surgeries they perform, and we support this in concept. I'd also like to add to the conversation you were just having with Julie. Today, people are used to surveys. A recommendation that we would make in an effort to get the public opinion and start measuring the performance in outpatient surgeries. When dealing with these accreditation agencies, the board can easily implement a program to deploy surveys that patients must respond to. They may be offered a survey just like they do with car auto repair. How was your experience? And these reports can be filed back to the board of directors, to the medical board, and if these reports are not filtered back with opinions, then you can start really watching out for these accreditation agencies and all the different surgical centers that they support.
Thank you. Okay.
Thank you.
Any other comments at any of the facilities? Okay, again, we thank you for your time. We will take these back and discuss them with the task force, and thank you again for coming out today.
Great, thank you. Thank you.
Thank you all, especially in the video conference participating. It looks like we can see you pretty well. Maybe we can do this more often, so thank you.